Planning. Planning is an essential first step in establishment of protected areas. Planning should take into account the legal context, including international conventions, decisions, guidelines and institutions, land and resource rights and tenure, and existing regulations and plans relating to land use, development, coastlines, biodiversity, marine resources, freshwater, minerals, climate and agriculture. Protected Areas Law should provide guidance on planning in relation to these legal contexts. It should provide for incorporation of international norms, identification and consultation with rights holders and stakeholders, and coordination with planning processes in different sectors. Protected Areas Law should also require development of a system plan to inform establishment of new protected areas. A system plan should identify conservation goals and needs, priority sites for inclusion in the protected areas system, key areas of connectivity between and around sites, existing and potential threats to the protected areas system, and opportunities for responding to these threats. Protected Areas Law should set out the scope and content of a system plan, the process and timeframe for developing and renewing a system plan, the authority responsible for developing and maintaining a system plan, principles and objectives to guide the development of a system plan, and mechanisms for implementation of a system plan. These provisions should consider links to other sectors and to international obligations. Protected Areas Law should also require a management plan for each site within a protected areas system. Protected Areas Law can provide for different types of protected areas. IUCN describes categories of protected areas which are recognised and used by international bodies and national governments. The categories are Category 1A, Strict Nature Reserve, in which human visitation, use and impacts are strictly controlled and limited to ensure protection of the conservation values. Category 1B, Wilderness Area, usually a large area without significant human habitation or modification, protected and managed to preserve its natural condition. Category 2, National Park, a large area set aside to protect ecological processes, species and ecosystems, which also provides a foundation for environmentally and culturally compatible, spiritual, scientific, educational, recreational and visitor opportunities. Category 3, Natural Monument or Feature, which can be a landform, seamount, submarine cavern, ancient grove or other geological or living feature. Category 4, Habitat or Species Management Area, which aims to protect particular species or habitats. Category 5, Protected Landscape or Seascape, where the interaction of people and nature over time has produced an area of distinct character with significant ecological, biological, cultural and scenic value. Category 6, Protected Area with Sustainable Use of Natural Resources, in which low-level, non-industrial use of natural resources compatible with nature conservation is one of the main aims. Different countries can use different categories or names for protected areas, but in all cases, Protected Areas Law should provide for different categories of protected areas to suit the management objectives and specific circumstances of different sites. Different protected areas categories can be used in conjunction with different governance types. Establishment. Protected Area Law should establish clear procedures for establishment and declaration of protected areas. Law should set out who can initiate the process for establishing a protected area and the procedures and criteria for doing so. Who should be involved in the establishment of protected areas and how stakeholders and the public can participate. which government agencies should be consulted or should give their consent for establishment of the protected area, and which authorities can formally declare a protected area and the legal process for doing so. Procedures for establishment and declaration of protected areas will differ for different protected area categories and governance types. These procedures can derive from statutory or customary law. Disestablishment or amendment. To ensure long-term protection, protected areas law should ensure that disestablishment or amendment of protected areas should only be allowed in exceptional circumstances and according to rigorous procedures. Main messages. Planning is an essential component of protected areas law and informs the establishment and management of protected areas. Protected areas law should recognise different types of protected areas. Protected areas law should prescribe strict criteria and procedures for establishing and disestablishing protected areas.